So Florida's got a new cell phone law addresses two real things: the texting and driving statute and using handheld devices without hands-free operation. Now the texting statute's pretty easy. It just modified it and makes texting and driving a primary offense, which means that the police officer can now pull you over if they see you texting and driving. There's some exceptions to those. I'll put those up on the screen so you can go over those now. The question with these exceptions is going to be, is it a viable defense in court, or is that going to be a hurdle that you're going to have to prove? In my opinion, the way it works out is the state's going to have to prove that you were not doing or not engaged in one of the exceptions. However, knowing the hearing officers and being to traffic court for the past several years, I have the feeling that, at least in Orlando, they're going to be ruling against drivers. But that's not even the big deal, because the texting and driving statute isn't big from a punishment standpoint. Sure, it's a moving violation. Who cares? The bigger thing is people riding dirty are going to get caught up by the police and being stopped and pulled over in situations where they weren't expecting to be pulled over, and it's going to result in a lot of arrests. Interestingly, the legislators mandated that the police officers note the race of the people they're stopping. They're looking at some numbers to figure out whether people are disproportionately affected based upon the color of their skin. Something else really fascinating with this statute change is the police are now required to affirmatively tell you that you have the right to refuse the search of your cell phone. This is a real big change to Fourth Amendment jurisprudence, because standard position is the police don't have to tell you anything. They can ask to search your property, and it's up to you to know that you can refuse the right to search. Here, the police have to tell you that you can decline the search, and they can't take your cell phone with you or with them as evidence pending obtaining a search warrant. Really powerful stuff. That applies to both the handheld operation of the statute as well as the texting portion of the statute. Now, on to the handheld portion. There's 3 times now that you can't use your cell phone in a standard manner. First is when you're driving through a construction zone with workers present. You got to be on the handheld device for that. Second is if you're going through a school zone. You got to be on your handheld device for, you got to be on mobile or hands-free device for that. And finally, if you're crossing through a school crossing zone, if you're within a school crossing zone, you've got to be hands-free. There is a diversionary program for first-time offenders. If you get caught texting and driving, you can take the texting and driving class. They reduce the fine amount, supposedly. It says may, so I don't know if they will or not, but you won't get any points on your license. And for the hands-free class or hands-free device, if you're using a cell phone when you shouldn't be, if you show the clerk of court proof that you purchased a hands-free device, they'll dismiss the violation. First offense only. The big thing here, keep your mouth shut if you're pulled over. The officer's going to be interviewing you, trying to lock you into a story that you were using your cell phone in a means that wasn't allowed. The allowable exception, the big one, is navigation or suspicious activity or weather alerts. All 3 of those can be used at any particular time, and that's an exception to the rule. So you won't be in trouble if you're using your phone for navigation, reporting an emergency or suspicious behavior, or weather alerts. Hit it hard, guys. If you have any questions, leave those in the comments.